Welcome back. I want to go across live to the Supreme Court. My colleague Anusha Soni is standing by. She's our legal correspondent. The big story breaking as we wait for the International Court of Justice to announce its order in the case of Kulbhushan Jadhav is that the hearing in the Supreme Court on the triple talaq matter is over. The Supreme Court has reserved its judgment. Anusha Soni, for the last 1 month, has been tracking every twist and turn, every aspect of this. I see she's got Indira Jaising with her. Let's go across straight to Anusha. Anusha, how did the hearing go? And most importantly, when will the verdict come?
So, Rahul, without further wait, let me just go right across to Indira Jaising, who has argued this matter extensively from Bebak Foundation, which is one of the petitioners against triple talaq in this case. And she's going to give us an account of how it actually was. Ma'am, in your opinion, the key argument in the court, do women have fundamental rights, and can personal laws be the subject of fundamental rights like equality and dignity? 60 years after independence, we're still debating it.
Yes, true. And the other key issue, of course, is the Supreme Court the custodian of these fundamental rights or not? Because the argument being made by Mr. Kapil Sibal on behalf of the Muslim Personal Law Board is that the Supreme Court cannot declare a personal law unconstitutional. God forbid if that happens. What will the meaning of that be? The meaning of that will be that for 50% of Indian humanity, the Constitution does not exist. Now, I think if the Supreme Court says that, it will become the laughing stock of all Supreme Courts in the world. Okay. Today, the Supreme Court of India is perceived by the international community as being a forward-looking court, as being a court which protects the fundamental rights of disempowered peoples, including women. If tomorrow Mr. Kapil Sibal's argument is accepted, we will be the singular and the only court in the world which does not protect the fundamental rights of women. Which is why I think the case is very significant.
Ma'am, what about Mr. Kapil Sibal's argument? We agree that it's a sin, we agree there is a problem, but do not interfere in religion. That's what he's arguing. And in fact, if you also said in the court that this is a persuasive argument because personal laws have not been subject to the test of fundamental rights in this country.
All right. The answer to that question is not, is it sinful or not? Is it constitutional or not? Yes, for 67 long years, from 1950 till 2017, the Supreme Court has dodged this question. The Supreme Court has abdicated its responsibility to decide this question. So, more than the Personal Law Board, I blame it on the Supreme Court. That why have you avoided this question? Hindu women have come to court, the court has said, not necessary to decide. Tribal women have come to court, the court has said, not necessary to decide. Look what happened in Nagaland. The government passed a law saying that women can be elected to public office. Tribal community came and said, this is not permitted under the Constitution of India. And a court in Guwahati upheld that argument. That is now pending in the Supreme Court. There's not a single community of women in India which is not being told hands off personal law. Why do we need a constitution? For me, as an Indian woman, as a Hindu Indian woman or as a Muslim Indian woman, the constitution is not even worth the paper it's written on. Right. You can treat it like a piece of paper which has no meaning. Right. If they accept the arguments of Mr. Kapil Sibal.
Right. Ma'am, thank you so much for speaking to us. So clearly, Rahul, the argument has been that are the fundamental rights subject, the personal law subject to the test of fundamental rights. I also have Farah Faiz with me, who's one of the petitioners in the case. She argued persuasively in this matter. Let's get in a word from her. Ma'am, सवाल ये उठा है कि कुरान में 3 तलाक की बात भले ही नहीं कही गई, वो जो इंस्टेंट ट्रिपल तलाक है, लेकिन ये मजहबी एक मसला है, एक इंटरनल मैटर है और इसमें लॉ और कोर्ट्स इंटरफेयर नहीं कर सकते।
देखिए, जो पर्सनल लॉ बोर्ड ने कहा है, इसीलिए हमने कहा है कि कुरान में एक डॉक्ट्राइन है नीड एंड नेसेसिटी का, और उसके लिए हमने दोनों वर्ड्स कोड की हुई है, सूरह नहल की भी, सूरह बकरा की भी, कि जब आदमी को एक इमरजेंसी पड़ती है तो वो उसके लिए शराब को भी परमिट कर दिया गया है, इवन जो सुअर का गोश्त है उसको भी परमिट कर दिया गया है, लेकिन सिर्फ इमरजेंसी के पीरियड तक। अगर हम उस चीज़ को एक परंपरा बना लेंगे कि बस ये अब हमारे लिए रेगुलराइज हो गई है और अब तो तो हम इस चीज़ को फॉलो करेंगे, तो ये गलत है। जब वो इमरजेंसी ख़त्म हो जाती है तो उस चीज़ के वो जो लॉ बना था उसका इफेक्ट भी ख़त्म हो जाता है। तो जो तलाक़ बिदअत इंट्रोड्यूस हुई थी हज़रत उमर सल्लल्लाहु अलैहि वसल्लम के टाइम पर, तो हज़रत उमर रज़ियल्लाहु ताला अन्हु के टाइम पर, तो वो चीज़ का ज़रूरत उस टाइम पे थी, आज नहीं है। आज ये तलाक़ बिदअत आज के सर्कमस्टांसिस के अकॉर्डिंग फिट नहीं होती, तो इस चीज़ को ख़त्म हो जाना चाहिए। तो यही हमारा मानना था कि 1400 साल से ये जो परंपरा चली आ रही है, ये जो क्लर्जी मैन है, क्लरिक्स हैं, उनके प्रेशर की वजह से या उनकी जो बोगस सुप्रीमेसी वो कायम रखना चाहते हैं, उसके चीज़ की वजह से ये जो चली आ रही है। लेकिन लोग इससे तरसते हैं, परेशान हैं, और ये अब खत्म हो जानी चाहिए।
फराह जी, बहुत बहुत शुक्रिया हमसे बात करने के लिए। राहुल, वन ऑफ द आर्ग्यूमेंट्स व्हिच इज स्टिल लेफ्ट टू बी अंडरस्टूड इज द आर्ग्यूमेंट ऑफ ऑल इंडिया मुस्लिम पर्सनल लॉ बोर्ड. Though in the popular discourse we may not like people who are defending triple talaq, but in the words of Justice Nariman, the argument put by Kapil Sibal did have some legal merit, that personal laws have not been subject to the test of fundamental rights, and there is some degree of merit in what Mr. Sibal is arguing, at least legally speaking. I have with me Dr. Soumya Saxena. She's a researcher also advising Law Commission on this entire debate around triple talaq and the reform in personal laws. Let's get in a word from her. Soumya, what is the argument of Kapil Sibal here? Legally speaking, what is his defense that he has put forward in the court?
So he is asserting that by virtue of being a personal law, it is not going to be subject to Article 13 of the Fundamental Rights. Now, my problem with that argument is by virtue of being in a form of a statute, which it is in the form of a statute with the Shariat Application Act of 1937, then this Dissolution of Muslim Marriages Act of 1939. So we're not making the argument here that it's not codified at all. Of course it is in a form of a statute, and by virtue of being written in the form of law, the Supreme Court has the right to interpret it and the Parliament has the right to legislate on it. So the fact that we cannot touch on religious law altogether, I think in itself is a flawed argument. Now, so far as, the idea of whether the reform is coming from within or whether the community has a consensus on the issue, now that's a different issue altogether, because we've been arguing for many years now that the reform must come from within, and this is as within as it's going to get. We have Muslim women here who are petitioning not just for a, they're not asking for a uniform civil code, they're asking for their freedom of religion, they're asking for their right to practice Islam in a free way, such that their own rights, which are protected by the Quran, are not taken away by a body which claims to be a representative of the entire Muslim community.
But Soumya, legally speaking, the precedents are clearly stating that you cannot subject them to the test of fundamental rights. There are judgments from the Bombay High Court. The famous case of Narsu Appu, that has been much cited about, that you cannot interfere. Law has, progressively interpreted in many ways, but there has been no open defiance to say that, personal laws are not above fundamental rights.
So, firstly, there is just one court judgment that says that is a high court judgment. I don't understand why we shouldn't be able to put it aside by, it'll be quite easy for the court to do so. And like Ms. Indra Jaising had made an argument in court, it's something that the court needs to exorcise itself of, because our version of secularism is never about distance between state and religion. It is precisely about state enabling religion. So one of the interesting arguments that Mr. Salman Khurshid had also made in one of the earlier days was that by sort of, talking about triple talaq is not a practice that's not fundamental to Islam, we're actually enabling Islam to be practiced in its truer, more, formal form, because the Quran does lay out a procedure for divorce, and that procedure for divorce is not talaqul bidat, right? Bidat by its very meaning means innovation. Clearly it's not mentioned. Now our argument cannot be that the Quran doesn't say anything against it, therefore it's valid. It does lay down a procedure, and that procedure should then be the law, if the personal law is to be derived from religion.
My last question to you about the legislative process now which the centre is mulling at. They're saying that all forms of talaq are bad within Islam because they're extrajudicial in nature. The centre is hinting towards an extensive codification and amendment process that can follow.
I am not sure what would come of that, but so far as the talaq being extrajudicial, I can only speak on the point of law here. So yes, it is extrajudicial, but we also have exceptions built into other religious personal law codes which allow us exceptions, right? Which allow for custom to creep in, and they allow for divorces to be taking place in a sort of a customary manner. Right. Now, that's no argument to make to say that, that just because it prevails, we shouldn't do anything about it. If the codification is to happen, the idea shouldn't be to abolish personal law. The idea should be to codify it as per the original interpretations of personal law, which a lot of women here are giving us quite willingly.
Absolutely. So, Rahul, as you heard, the argument is now moved a step forward. The centre has said that they are going to go forward. They'll codify this process. Now, the key question is, what will be the form of codification? Everyone is awaiting the judgment of the Supreme Court.
So that's the big question, Anusha, that I have for you. How soon will the verdict now come out? And what this shows to me is that if the Supreme Court is serious about resolving an important matter, 5 days is all it took. I thought this could run into several weeks. 5 days, they've heard everybody, sat through. This is really how the Supreme Court ought to behave, and that's how we'll get judgments. How soon will the judgment come out, and can't this happen more frequently? Back-to-back hearings, listen to everyone involved, and then say what you have to.
Absolutely true, Rahul. And in fact, you know, one of the when the earlier this hearing was supposed to be scheduled, the time frame that the court had in mind was about 2 weeks. However, when they began the hearing, they limited the issues. They said at this point we will not hear on the polygamy, we will not hear on halala. Clearly, the centre, when the date was being fixed, was saying that we need more time. We cannot argue it in the summer vacations. It was merely on the insistence of the Chief Justice of India that this matter was listed during the summer vacations, and with the sort of you know, lack of judges and vacancies and the problem of long pending issues in this country. Clearly, this is one approach that is required of the judiciary, to pick up these big issues and resolve them as soon as possible, so that 50% of this population, at least in this case of triple talaq, seeks answers. Do women have
these are the kind of burning issues that the judges of the Supreme Court need to apply their minds on. Kapil Sankla, this is like the one question every observer who's looking at it from the outside has. And the one question all lawyers are reluctant to answer. What do you think will happen?
Well, I'm not. I think it should happen. I think the time has come. And I'm very sure
of course,
that
that's your view. I'm saying in terms of how the proceedings have gone in the courts, and what the judges have said in their oral observations, to the extent that that may indicate what's in their mind.
Absolutely. So, the observations of the court have been to the effect that various Muslim countries where Muslim law also prevails have either abolished triple talaq or put stringent conditions. So therefore, that is my view, that why should India suffer? Why should Indian Muslim women suffer? So as I was saying, that the time has come that these regressive customary laws...
So what do you think will happen? They'll strike it down, and what comes in its place? Will the government have to come up with a new law?
So either the government will legislate and come with the new law, or would have a panel of Muslim leaders, religious leaders coming up with a better system, or probably the court itself can come up with certain guidelines which would either be adhered to or would be the basics to be followed in creating new laws. So therefore, at this moment, as we were saying, that this particular triple talaq system being regressive, the new system should be progressive, and though everybody is scared to use the word, the common civil code, but it is in the right direction.
Oh, absolutely. Triple talaq is the first step.
Yes.
There must be a debate about the common civil code, and India must head in that direction for all religions.
Yes.
No sensible, right-thinking person can say that India should not have a common civil code. It's high time that we get over this whole politics. You know, and the leaders who are politicians who have appeared in court, in private, when you speak to them, they say something else. When they appear in court, they say something totally different. This is the kind of hypocrisy of the so-called liberal class, which really is doing great disservice to Muslim women themselves. And that really is a travesty that needs to end.